Hello and welcome to this second tutorial key points video for W201. What we looked at in the tutorial were a number of key topics that you need to make sure that you can fully describe and explain and weigh up the arguments for and against the doctrine. So we started off by looking at parliamentary sovereignty, and of course Dicey comes in very helpful here, not because you might agree or disagree with him, but because he sets out a framework for any discussion. So to paraphrase his 3 points, the first is that Parliament can pass any law that it wants, and he was contrasting that with the United States, where Congress can't because the Supreme Court can declare a piece of legislation unconstitutional. The second was that no Parliament is bound by its predecessors. We don't have entrenchment in the English system. And the third point was that no court can question what Parliament has done. And what we did was to discuss a comment from Robin Cook, where he said that there is no more elitist, authoritarian, hierarchical claptrap than the doctrine of parliamentary sovereignty. Discuss. Well, whether you agree with the doctrine or not, what we're looking for is a critical examination of the assertions that have been made by Dicey and other writers, and whether it is a helpful doctrine or actually something that obscures. Then we looked at the institutions of government, and do make sure that you have a good understanding of what roles are played by each institution. And of course, much of this was dealt with in W200. But look at the composition of Parliament, how Parliament scrutinises the executive. Look at legislation and make sure that you can describe the process of the creation of legislation. On the executive, how is it structured in terms of cabinet ministers, government departments and civil servants? And the legal system, again, a bit of revision from W200, the court structure, the role of the various individuals. We then looked at the important concept of the royal prerogative. The question at the centre of this is, where does the executive get its authority to act? In many cases, the authority comes from Parliament that has given it in a statute. But there are some things where the authority is the royal prerogative. It's a power that the king once had, which has not yet been abolished by Parliament or put on a statutory footing. I've sent you some material about the royal prerogative and examples, and do make sure that you are both able to define what the royal prerogative is, give some examples, and be able to discuss whether it ought all to be put onto a statutory footing. We then did a brief introduction to the issue of human rights. Key points to remember here is that the traditional approach was that everything is allowed except what is banned. And English liberty was built on that for many centuries. Its weakness is that if you get a government intervening more and more in what we do, there are no safeguards to it banning more and more things. So with the Human Rights Act, we take a different approach and say there are certain rights which need to be respected, and the law must make provision for that. And so we will be looking at the European Convention on Human Rights. Make sure that you know your way around the convention, which are the important rights. So if I were to throw out a question to you as to what does Article 8 deal with, you should be able immediately to answer. Those are the topics ahead, but of course perhaps a long way in the future now, it would seem. You've got the second TMA due in early May. And two parts to the question. The first one is about explaining and defining and applying law to the facts. It's a problem question, and you need to apply the relevant case law. You'll find this in the textbook, and in some of the cases that you might want to refer to are the Queen and Howell, DPP and Percy, Redmond Bate and the DPP. But do have a look in the relevant section of your manual for those cases that relate. But it's not enough just to make reference to what the manual says. Research these areas. The best thing you can do is actually look at the cases themselves. Look at the judges' reasoning as they sometimes appear to be arguing with themselves as they weigh up one argument against another. What those judges are doing is giving critical evaluation of the arguments that have been presented to them, and that's what needs to come over in your TMA if it's to get the highest marks. The second part itself has two parts. Again, there's an explanation needed, and you will do that with reference to case law. You need to explain the interplay between Articles 8 and 10. You need to explain this concept of horizontal effect. Judicial review initially was seen as something that the individual will use in a dispute with the executive part of the state. But it's widened, and these cases, of course, are individuals, albeit perhaps an individual person and an individual company, arguing. And you need to come to a reasoned conclusion. You also need, in the second part, to do evaluation. You need to explain what the law was prior to the 1981 Act, how the Act changed things, and look at the arguments about how effective the 1981 Act is in actually conforming and giving effect to the Convention. There are different views. A description of those views would be great, but the best thing again is if you look at these arguments, weigh them up, explain why you found one person's view more or less convincing than the other and why that was. So that's TMA02. I look forward to receiving it in about a month's time, and look forward to presenting my next video after the next tutorial.